Welcome everyone. Let's make a start. So good afternoon and thank you for joining today's session on such a hot sweltering day. I'm Sean Gibb. I'm the Events and Marketing Manager here at Pro Manchester, and I'm delighted to welcome you to today's it's an economic update webinar, the rescue package, a look at the current state of the economy and a suite of new measures introduced to give businesses breathing space, hosted by Prosperity Law LLP. Today's speakers are Simon Gerard, Head of Insolvency at Prosperity Law, Alessandro Sedoli, Licensed Insolvency Practitioner at K. Johnson G, and Jonathan Seeley, CEO of Hope Capital. Following today's session, I'll send out a post-event email which will contain any post-event collateral, any links. There'll be some signposting to our other events that we do, Pro Manchester and our new YouTube channel. So it'd be great if you could jump on there and like and subscribe. And then you can stay up to date with all of our latest recordings and content. And the email will also contain a feedback form. If you could fill this in, it would be really helpful to us, just to continue to improve our offerings and provide consistently great content. We're always looking for new ideas, and you know, all of your feedback is welcome. Throughout the session, please make use of the chat function, which is the two squares with a question mark in, so you can ask any questions, make any comments, observations. You can send those through to me privately or share with everyone in the group, and we'll try and answer as many of those as possible towards the end of today's session. So without further ado, I will hand you over to Simon.
Good afternoon, everyone, and thank you for taking time out of your day to dial into this webinar, especially given the wonderful weather that we've got outside today. As Sean's already mentioned, my name is Simon Gerard, and I head up the insolvency team at Prosperity Law. By way of brief background for those of you that might not be familiar with us, we're a commercial law firm based in Spinningfields, Manchester, and we've got offices in Liverpool and Norden too. For this segment of today's webinar, I'll be dissecting the state of the market from a commercial lawyer's perspective, with a particular focus on the trends that are beginning to take shape within the market, particularly the insolvency market, and perhaps more importantly, what is to come. During Boris Johnson's final stand at the daily briefings on Tuesday, he commented that there will be serious economic consequences as a result of the pandemic. Dr. Whitty also made it clear that we will be living with the virus for a significant amount of time. And in light of these stark predictions, we must take stock of the current state of the economy and prepare for the future. Given the vast majority of businesses have had to either cease trading or enter into a holding pattern, or have otherwise been negatively affected by the lockdown, the natural expectation is that many businesses wouldn't have the cash reserves to survive a significant period of time, and this would result in a mass increase in insolvencies and bankruptcies. But that hasn't been the case, or at least not yet. At the risk of turning the webinar into a government daily briefing, I want to run you through some statistics on the number of insolvencies in England and Wales over the past couple of months. And as you can see from this slide, there were fewer corporate insolvencies in May 2020 than May 2019. And perhaps most significantly, there was a 27% reduction in corporate insolvencies from April 2020. And you can see quite clearly here that from the turn of the year, there's been a steady decline, which doesn't correlate with the same decline that we saw the previous year. Now, like many of you, I suspect you'd be quite surprised at these statistics, and it does raise a question as to whether there are hundreds, if not thousands, of zombie companies out there, and whether, regrettably, a tsunami of insolvencies and bankruptcies are eventually coming down the pipeline in light of the stark warning we have about an economic crisis. The reason for the rather strange trend in declining insolvency rates during an economic crisis or an impending economic crisis is due to the measures that have been put into place to prop up companies to give them the best chance to stay afloat in these tricky times. As you can see from this slide, companies have been thrown a life vest in the form of several initiatives, the business rate holidays, VAT deferral, which actually ends this month, the corporate insolvency and governance bill, which I will touch upon very shortly, the furlough scheme, which is about to change in the coming months and will end in October, and the business interruption loan scheme. It's also worth bearing in mind that most commonly winding up petitions are instituted by HMRC and landlords. HMRC has stepped its foot off the enforcement pedal, at least for the time being, and landlords in particular have been the focus of the government's attempts to restrict enforcement action. The question remains, though, that what happens when this suite of measures in the centre of the slide here are no longer in place? They are but temporary measures. And one sensible point of view is that for those businesses to survive, then they're going to need to put into place other measures. In particular, they're going to need a fast restart to the economy. Now, we've all seen the long queues outside of Primark on the news, and mercifully the pubs open next week. But I find it difficult to see how a fast start in a post-COVID world is even possible. Most businesses, particularly in the hospitality sector, will need to limit their capacity, and that places a correlating restriction on income and profit. And indeed, many businesses will need to invest in new infrastructure to become COVID secure and comply with guidelines, and they may need to borrow and therefore add to the indebtedness of the company. So against that backdrop and in this vacuum, to give businesses the best possible chance of success, the government has introduced new measures, a rescue package, under the Corporate Insolvency and Governance Bill, or Act, as it will shortly be known as. The government's fast-tracked this legislation through Parliament. For those of you who are not already familiar with it, the purpose of it is set out on the screen here, which I've highlighted the relevant sections for you. The fundamental purpose is to introduce a suite of new measures that will give businesses breathing space from creditors in order to continue trading. The legislation is in the very final stages and is expected to come into law any day now. Now, some of the measures are temporary as a direct reaction to COVID-19, and some of the measures are permanent and have been discussed for some time, and the government's deemed now the right time to introduce them. And broadly speaking, the measures are highlighted on your slides for you there. They centre around enforcement restrictions on wrongful trading, termination clauses, a new scheme of moratoriums, and a restructuring scheme. For this segment of the webinar, I'll be touching on statutory demands, winding up petitions, wrongful trading and termination clauses. I'll give you only a brief overview of these changes. I won't be going into the minutiae, but feel free to reach out if you'd like to discuss them in more detail offline. So dealing first with the enforcement element, statutory demands and winding up petitions. The new measures will prevent the presentation of a winding up petition against a company based on a statutory demand that was issued between the 1st of March and the 30th of June, or 1 month after coming into force. So that appears to be most likely the end of July. Therefore, it'll act retrospectively and it'll capture statutory demands that have already been presented, effectively invalidating them. It also applies to winding up orders that have already been made, effectively bringing these companies back to life, and those orders can be declared void. Where a winding up petition is presented, the new measures place a very high threshold on creditors to satisfy the court that the debtor has not been financially affected by COVID-19. You'll see the test on your on the right-hand side of your screen there. It essentially creates a but-for COVID-19 test. and it's extremely widely drafted. It's very difficult for me to think of any businesses that haven't been financially affected as a result of COVID-19. Another important consideration to bear in mind as well, and key change under the Act, is the advertisement of a winding up petition, which is one of the procedural steps, but an important procedural step, because that really puts the company at the point of no return, and is usually at the point when lenders freeze accounts. That can't be advertised until that but-for COVID-19 test has been met. Now, there's been debates within Parliament as to whether or not the long stop date of 30th of June or 1 month after is sufficient time. The House of Commons and the House of Lords have been pushing for a 30th of September date, and I did notice an amendment to that effect, proposed amendment to that effect in the bill, but we wait to see how it transpires when it's actually scribed into law. Another important thing to remember is that the bill itself has built within it mechanisms for that long stop date to be extended, so don't be surprised if 30th of July turns into 30th of September or even October. Now, this particular new measures has been criticised by some as limiting the rights of creditors to recover the debts, and this could lead to an increased reluctance on the part of lenders to offer support in times of need, but the long stop date is the answer apparently to mitigate this particular worry. And one important thing to remember as well is that the bill only relates to companies. It doesn't relate to individuals, so there's no reciprocal arrangement or protection for individuals. They can still be the subject of winding up bankruptcy petitions and statute demands. So turning then to wrongful trading, the bill proposes to suspend wrongful trading provisions under the Insolvency Act. Now, for those of you that might not be familiar with this particular concept, in essence, directors can be found liable to contribute to the losses of a company if that person knew or ought to have concluded that there was no reasonable prospect that the company would avoid insolvency. Now, as with statute demands, it'll apply retrospectively from the 1st of March until 30th of June or July, whenever the long stop date is finally crystallised in the Act, when it takes force. And essentially, what this will mean is that when a court considering whether or not to declare a director liable to contribute to the company's assets under the wrongful trading provisions, the court can't take into account losses incurred between that prohibited period of 1st of March and whenever the long stop date is eventually dealt with. Now, this has been lauded by many as providing a protective bubble for directors. However, in practice, wrongful trading claims are rarely pursued, or at least they're rarer than other claims that are pursued by insolvency practitioners. And this is simply because it's much easier to make out a claim for, say, misfeasance or breach of fiduciary duties. Now, in this context, the misfeasance and fiduciary duties don't change under this new restriction. It's just wrongful trading. So directors will still have a duty when a company is insolvent or likely to become insolvent to exercise their powers in the interest of creditors. Now, directors can take steps to protect themselves to avoid falling foul of this rule. In particular, it's important to make contemporaneous notes of the reasons for decisions, simply so that you can produce that as evidence down the track if needs be, and to avoid being judged under the harsh light of hindsight. And I'd be happy to talk with anyone separately about the other steps they can take. So the next topic that I'm going to touch upon, and it's the final substantive topic of my segment of this webinar, are termination clauses. Termination clauses are a common feature within most commercial contracts, and under the new measures, the termination contracts in circumstances where a company enters into an insolvency procedure, liquidation or administration, they're now prohibited. So that applies to contracts relating to the supply of goods and services, and the real spirit of this new measure is to enable companies to preserve their supply lines so that they can trade through the situation and go through a rescue process. Now, it does seem rather harsh to effectively force somebody to continue trading with a company that has is apparently insolvent, and the measures do contain safeguards for suppliers to ensure that continued supplies are paid for, and there's a provision within the bill to apply to the court to terminate the contracts on grounds of hardship. And it's interesting to note that there's actually no requirement for exceptional hardship. So we wait to see how this provision is applied in practice, although one obvious reason that springs to mind is where one's own solvency may be affected if you continue to supply. And the other point to note is that suppliers can still terminate contracts on other grounds, provided they don't relate to the insolvency of the company. So if there's been another breach, then you can terminate on that basis. And as a consequence, we might see the commercial culture changing somewhat. So whereby people become less forgiving of defaults, particularly if they think that a company to which they're providing goods and services might become insolvent. Now, on your slide there, you've got the lifespan of a hypothetical contract, which just basically runs you through the commencement, the insolvency event, whereby you cannot terminate. If there's hardship after the insolvency event, by continuing to supply, you can apply to court, or if there's another breach, then you can terminate the contract on that basis. So, to summarise, I expect the downward curve or certainly a plateau in the number of insolvencies to continue until at least August, possibly into September, October, by which time businesses will have to share more of the furlough scheme burden. And changes in societal and consumer behaviours will become more apparent. It may be the case that there's simply not a market for certain services and goods anymore, and in particular high street stores and some travel companies spring to mind, although I'm sure we'll still want to go on holiday. The bill will introduce new short-term restrictions on creditors, and this is welcome relief for debtors. It does give them breathing room. However, it remains to be seen if a 1 month period is going to be enough, and I would expect that period to be extended to September, quite possibly into October. And one other final comment from me is that the new measures all contain features that make them ripe for interpretation depending on one's circumstance. So I expect there to be satellite litigation, particularly in relation to winding up petitions. For instance, where it's debatable whether a company would have become insolvent even without COVID-19. I certainly have one of those cases on at the moment, and I expect there to be some litigation against directors who perhaps misapplied the government business interruptions loan. I certainly expect there to be a high degree of scrutiny on that particular affair of the companies. So that's all from me, and I will now hand you over to Alessandro. Thank you.
Okay, good morning everyone, well, good afternoon rather. Yeah, thanks Simon. Alessandro here from K Johnson G. I'm a solvency practitioner with the firm. I've been with them now for the past 2 years and licensed for the past 7. So what am I looking to cover today? I was going to give a bit of a market update, but after seeing Simon's slides this morning, I didn't think there's any point in repeating the sort of stats that we're seeing at the moment. So it's more anecdotal from my point of view in terms of the market. And the reality is that it's exactly as Simon's described. There's a lot less clients or potential clients taking action. Rather, there's a lot more inquiries. People are really just unsure about what to do, when to do it. And I think the government relaxing measures this month has probably come at a good time to be able to try and start some sort of normality, try and see what a new normality for a lot of retail at least looks like. And I think a lot of people are at least going to try and give it a go. And then those inquiries may well turn into successful companies, or they may need to take further advice. So we'll see where that goes in the next couple of months. So in terms of what I'm actually going to cover today, I'm looking at the two new processes that have been brought in, are being brought in by the Corporate Insolvency and Governance Bill. Those are the moratorium and what's being called the arrangements and reconstructions for companies in financial difficulty. And again, this is going to be a brief overview purely because the amount of detail that's around and in these sort of things, lots of caveats, etc. So a brief overview of what the process is, but more importantly, what the effect on the company and creditors of that company are going to be. So the moratorium. Before I describe what it is, I thought it'd be good to talk about the term that's being thrown around a lot at the moment about debtor in possession and what it is. I mean, effectively, what debtor in possession means is that the directors of the company are going to retain the control throughout the moratorium. So we're not passing control or the trading across to someone like an administrator. Why is that important? Well, the government have been consulting on bringing something like this in for the past 2 years. Why? Because they're trying to make UK corporate recovery and insolvency more competitive. If you look to the US market, you've got something like Chapter 11 bankruptcy, which effectively is what the moratorium is trying to emulate, where you're giving a breathing space to the company to try and restructure, refinance, find investment of some sort without the threat of anything happening to it from a creditor or a charge holder, for example. So that's effectively what it is. This is the process that's going to try and save as many companies as possible by giving them that breathing space. Main factors are going to be that we're going to have a new office holder called a monitor, which is going to be someone like myself, which is an insolvency practitioner. And there's two main routes in, which we'll cover both of them, one being out of court, which will be for the majority of companies, and one being through the court itself. So out of court. This is going to be, like I said, the case for the majority of companies out there, purely because of the eligibility requirements. Basically, to be an eligible company, it's done by exclusion, i.e. everybody's eligible unless they've been in a moratorium, in a voluntary arrangement, or been in administration in the past 12 months. Specifically for the out of court process, the company can't be subject to a winding up petition. So what that means effectively is that unless you've been in a winding up petition and get placed against you, your company's going to be eligible for the out of court process. Caveat that by saying, with the COVID exceptions included in the bill, these will not be applied. These exclusions I've just mentioned will not be applied for the first month. So we're expecting it to come in end of June, beginning of July. So by the end of July, beginning of August, it'll be back to, if you are a company with a winding up petition against you, you're going to have to go through the court process. So in terms of the out of court process, it's summarised there in 3 steps, and it is as simple as is put there. Being an eligible company, you're filing the documents that are listed in the Act with the court stamps the documents, and the company is put into a moratorium, and the proposed monitor becomes the monitor. A little bit of detail I want to highlight in the terms of the process here. The documents are pretty much like your standard documents in terms of identifying the company, confirming its eligibility. One thing that is different, though, is going to be what I've highlighted at the bottom here, the proposed monitor's statement to the court. And that's saying that it is going to result, or would result in a rescue as a going concern. Now, would result has been part of the debate in terms of amendments at the moment to see whether they could lower that threshold, because the word would is implying a probability rather than a possibility. So for a monitor to put their license to say that it's definitely going to result in a rescue as a going concern, it's a high threshold to meet. So we'll see if that ends up being amended, but at the moment it seems like it might be quite a hard test to meet. In terms of the out of court process, again, relatively simple in that the documents are filed at court, you have a hearing, and then the judge can make any order that they see fit. I suppose the bit to highlight here, again, is that the fact the judge is only going to grant it, and it's put there in the 3rd bullet point, if they're satisfied the moratorium will achieve a better result for the company's creditors as a whole compared to being wound up. Now, from an insolvency practitioner's point of view, that's not going to be hard to prove. You should be able to, as an insolvency practitioner, draft something called an estimated outcome statement. We use them in company voluntary arrangements, administrations, individual voluntary arrangements. So If you're putting your name to this as a monitor and you believe that it's going to save the company as a going concern, then you shouldn't have any problems in justifying that it's going to be a better result for company creditors as a whole than if it was wound up. In terms of the actual moratorium itself, a bit of detail there on that slide. I'm not going to go through it all purely for time issues, but the bits I'll highlight. The actual period itself for the moratorium is going to be 20 business days, which start the day after the application. So effectively, you're getting a month to try and save the company. And then in terms of extending it, this is going to be the interesting point when it actually comes to being done, because the directors can choose to do it with consent of the creditors or not. By doing it without the consent of the creditors, they get a maximum of 20 extra business days. Doing it with the consent of the creditors, they can propose a period anything up to a year. So it could be quite an intensive, long process, or they can go to court. And again, the court's going to have the discretion about how long to grant the moratorium for, but you're probably going to face a lot more scrutiny there from the court about why you're needing to extend it. All three of those need to be done after the 15th business day and can't be done any earlier in the process. In terms of coming to an end, again, I'm only going to highlight one of these, and that's the monitor's duty here. And the monitor's only going to be able to bring it to an end in 3 instances. 1, where this company's been saved as a going concern. 2, where the company cannot be saved as a going concern. Or 3, the company can't pay its trading debts. So it's sort of showing you there how intensive the company's, the monitor's responsibility in relation to the company is going to be to make sure they've got their hand on the pulse about what's happening. In reality, how do I see that working out? You'll probably have the monitor involved in any sort of negotiation, restructure, so they'll be very much aware of what's happening in terms of trying to rescue the company. So it shouldn't be too much of a stretch for them to know exactly if it's going to or not going to save the company. In terms of being able to meet the ongoing debts, that's probably going to end up being something agreed between the company and the monitor about how they're going to actually be involved. So effect on the company itself. If you've got a moratorium, you're effectively protected from any action. You're protected from attack. So what things are we talking about? We're talking about enforcement action. So a hire purchase creditor coming in and taking back assets. We're talking about a floating charge creditor allowing their charge to crystallize over assets. We're also talking about creditors not being allowed to take any insolvency action. So not allowed to issue winding up petitions. Floating charge creditors not allowed to put the company into administration. It's a genuine stay on anything that could happen against the company. Now, the one caveat I'll add to that is the Secretary of State, will be allowed to issue a winding up petition against the company on public interest grounds. But again, these are going to be few and far between, these petitions actually being brought forward. So in terms of the routes to save, you can see those there. The other bit I want to highlight again is about being able to meet those costs during trading. I'll speak in a second about the actual costs that need to be met. But if a company can't just meet its minimum costs and overheads in the trading period of 20 days, you have to ask yourself whether there really is a chance here that a refinance or arrangement is actually going to be able to be come to. So in terms of the actual effect on the creditors, well, in some ways, it's just the opposite of what the positives are for the company itself. It's the restriction side of it. So you can't bring the insolvency proceedings, you can't enforce or take legal action. And the most important bit I want to raise from this slide here, if it's still there. Yeah, sorry, I lost my screen for a second there. It's about relevant creditors. So what's a relevant creditor? So the effect of the moratorium is going to bring 2 new sets of creditors into insolvency, and they're going to be grouped A and group B. Group A is going to be the actual creditors you create during the moratorium. So things like your rent during that period, the wages during the period, and then the specific debts that are going to survive the moratorium, so have to be paid throughout it. And the way it's phrased is that they don't have a payment holiday. And the one I want to draw your attention to, and I'll read it because I want to make sure we can get it right, is debts and other liabilities arising under contract or other instruments involving financial services. Very wide drafting, and effectively they give some examples of it being finance leases or factoring agreements. So those are still going to have to be met, and those end up being Group A and the relevant creditors, which can be important. So it will be important in a subsequent liquidation, administration, or reconstructing, which we'll talk about. Everybody else falls into Group B. Okay. Okay, so the other measure that's being brought in is the arrangement and reconstruction. What is it? Well, it's a new rescue tool. It's about coming to an arrangement or compromise with the creditors about debts or financial obligations that are owed. What's the difference between the compromise and arrangement? Well, it's going to be, they're effectively labels. Anything that's asking creditors to accept a little bit less on debt is going to be a compromise. Anything else that involves a little bit more restructuring and movement of debt, etc., is going to be classed as an arrangement. So there's no actual proper definition there, but it's more of a feel on those ones. So in terms of the actual arrangements and reconstruction, what are they and who's going to be able to benefit from them? Sorry, the wording of who's going to be able to benefit, again, extremely widely drafted, and it's been done with the view that they want as many companies out there, viable companies is the term, to benefit from this as much as possible. So it's available when a company is encountered or is likely to encounter financial difficulty, and it's going to be affected, will or may affect the ability to carry on the business as a going concern. May affect the ability of a business to carry on as a going concern could be a number of different scenarios. So I can see that if a company was going to pursue this, going to be a lot of definitions of what that may affect may end up being. So the process is a little bit more involved than what a moratorium is. Again, a brief overview of it is that there has to be an application to court to be able to summon a meeting to consider a proposal. At the meeting, there's got to be 75% approval. And then once you've had the meeting and got that approval, you've got to go back to court for sanction. And the court has discretion whether to grant it or not. Why is that important? Well, it's important because of the phrase on the right, the cross-class cram down, the new tongue twister that's being invented. What is the cross-class cram down? The cross-class cram down is a situation whereby if you have creditors or members who are not going to financially benefit from the proposal, and they vote against it, or they're not in favour of it, sorry, the judge can still give sanction to the proposal. And the way that it is drafted in the bill is to give it it gives two tests, and effectively it all comes down to the economic effect of the compromise. So test A is going to be the court satisfied that none of the dissenters were worse off than in a relative alternative. And B, it's been agreed by 75% of the in value voting creditors. So, and they are in the money. So as long as you are in the money, i.e. getting a return, you are going to be able to vote and approve it. But if you're not, effectively your power is taken away. You don't have the power to vote it down. And the court will take that into consideration when it's looking at sanctioning the compromise or the arrangement. And what's a relative alternate? Again, the court has got discretion on this. But most likely, if a company is facing financial difficulty, it's going to be a liquidation or an administration. So the effect on the parties, it's a short slide because the reality is it comes down to what the arrangement or the proposal is going to be. We can't say anything more than that. What we do know is if you're out the money in the relevant alternative, you're not going to have the ability to impact this. What we can say for the company is that it's a flexible restructuring plan. And it's got no real restrictions. It can be made up of any way that you want to deal with your financial difficulties, but it just has to be able to address that financial difficulty. Okay, so in terms of conclusion, moratorium, I think it's going to be a useful tool. I think what we've got here is an amalgamation of the small company moratorium that's there at the moment and the notice of intention to appoint an administrator, but actually defined as its own process now, which a lot of companies are going to be able to benefit from. But I worry that threshold of likely would rescue as a going concern might prevent a lot of companies that could do with a moratorium being pushed into administration instead. I think that the bigger implication of these two, though, is going to be whether the arrangement and reconstruction is cost efficient. It involves two applications to court and a meeting and a proposal being drafted. The reality is a CVA only has a proposal and a meeting. You're going to be incurring a lot more costs by going down this route. So I can see it being used by big corporations. I think anything medium and lower who don't really have the different level of bonds or creditor classes or member classes, they're just not going to be affected by it, and the CVA will just be easier for them. The last point I'll make as well is that floating charge holders could have schemes sort of forced upon them that aren't going to be anything they'd like to have done. They're going to cede control effectively when, if the floating charge has been drafted correctly, they've got the ability to bring in administrators. So are we going to see a change in the way that charge documentation, loan documentation is drafted? Probably. It's probably going to be a lot harsher in terms of default events, because they're going to be looking at ways to be able to take control earlier rather than being subjected to a scheme that they don't want to go down. Like I said, brief overview of the two processes being brought in, and if you've got any questions, we'll speak about them at the end. Thanks very much.
There we go. Can you hear me, guys? Hi there, I'm Jonathan Seeley. Thank you for having me. I'm CEO of Hope Capital. We're a specialist short-term property finance lender. I just thought I'd run through a few of the questions that we, as a finance company, have been asked the most really during the lockdown period. So, trends in the marketplace. How has COVID-19 affected lenders such as ourselves? How has COVID-19 hampered our appetite to lend, and how has this been mitigated? So, Hope Capital, like the rest of the UK economy, has been impacted hugely by COVID-19. The impact of the government initiatives to control the virus on external stakeholders, in particular valuers, resulted in them being unable to fulfil their roles by undertaking internal valuations that we require for our lending. This prevented us from being able to complete new transactions in both April and May 2020. So we effectively placed business on pause during the period of lockdown, focusing on cash control and treasury, account management, strategizing, identifying opportunities for the business for as and when lockdown will be lifted, and when our stakeholders were then able to recommence their roles, which I do actually feel is really starting to happen now. So during the lockdown, we implemented a highly effective and successful business continuation plan. This meant all our colleagues were able to work remotely, maintaining high productivity and efficiency. The success of the business continuation plan enabled us as a company then to keep its focus, to prepare for our sort of strong return to the market, which we have now done. This return coincided with a series of new and enhanced propositions centered around affordability for borrowers in these difficult times, including new, unique product developments coupled with an innovative service approach. So our appetite to lend has always been strong. However, we needed to equally maintain a prudent risk appetite, which we believe we achieved. We needed to remain in the forefront of the market at all times, especially now that we're back lending again. Additionally, we mitigated the unforeseen and unprecedented risk of COVID-19 presented to our stakeholders, which resulted in them unable to fulfill their roles during lockdown to help future-proof our business. So, for example, as I mentioned earlier, we weren't able to lend because without valuers being able to internally inspect a property, we weren't able to release the funding at that time. We've now built provisions for that, for automated desktop and drive-by valuations, which then we don't need for internal valuations. We are doing that with a more limited risk appetite on LTVs, but we can now continue to lend without valuers going internal. So moving on to sort of more financial market predictions. How might the impending financial crisis change lender approaches? Are lenders seeing an increase in borrowers defaulting? And what's being done to help those borrowers unable to redeem their loans? So we lifted the pause on new business from the 28th of May with a full relaunch of new products. Again, like I said, centered around the affordability of the borrower, which had a considerable response to our pipeline with new distribution growing as we speak. We recognized very early on that the pandemic was and still is probably likely to have a very significant impact and effect for an unforeseen period. We're closely monitoring and managing the effects, as it has on both the global and UK economies, especially mortgage lending, the short-term lending space, which we're in, property prices, unemployment, whilst also generating sort of high-quality new business to continue our growth plans. So in terms of borrowers defaulting, everything we do is about treating customers fairly. We've taken a very preemptive approach for account management. We've been in regular contact throughout COVID-19 with all of our borrowers. Whether their redemptions were due during the lockdown period, later on this year, or even into 2021, we wanted to immediately reassure our borrowers that we were here to help them, and we opened up a dialogue for discussion immediately. Again, this was to ensure that we have early sight of any potential issues. We can work with the borrower and find a suitable individual solution, as every loan we sort of write is completely different, has its own concerns and issues. We've been able to provide forbearance to our borrowers, typically via loan extensions and rolling up interest due to their exit strategies being delayed. We've also been able to secure additional security from the borrowers to reduce risk as part of the terms and conditions of the extension. So, for example, we've taken security over another unencumbered property which the borrower has within their portfolio or owns, in order to be able to extend their current loan facility with us with no further payments being made, and obviously helping with their affordability of the loan. I am proud to say that some of these borrowers that we provided forbearance to during lockdown have actually been able to redeem their loans in full now. Now that there's been a partial lifting of the lockdown and the property market, mortgage lending market, and sort of the economy as a whole starts to try and recover, which is really good to see. Moving on to lending appetite. Are lenders going to be less inclined to lend in light of the restrictions imposed on them as a result of the new measures in the Corporate Insolvency and Governance Bill? Yeah, probably is the easiest answer. I think, obviously, this is where I'd speak to both Simon and Alessandro for advice. However, although I'm not a solicitor or an insolvency practitioner, my view is that the bill effectively makes it harder, but not impossible, for lenders to recover debts and enforce their sort of contractual obligations. We see the FCA, we've seen a lot of the published guidance, and the FCA has now published further final guidance on sort of temporary financial relief for customers impacted by COVID-19, following feedback on its draft guidance for mortgages. So it has now been announced that the moratorium of Part 55 court proceedings, possession proceedings, which was due to come to an end of June, is going to be extended until 23rd of August. However, we are now receiving information that suggests that the courts are gearing up to accept claims from an earlier date. However, at the moment, I'd say there's very little clarity and distinction for us as a short-term lender, for whom the enforcement moratorium could be disproportionately damaging. That said, Hope Capital are an unregulated lender in the sector. We offer finance for business purposes, taking property as security, but not for the purchase of one's own home that they're to live in. For example, this would be a regulated mortgage contract. That's quite an important distinction, as the FCA has mainly its only jurisdiction over regulated matters, entities and individuals. But the use of the word home within the FCA press release rather than property is important. Home obviously has a natural meaning, i.e. a place where private individuals reside and live. Accordingly, it may follow that recovery of vacant commercial or even residential properties subject to continuing occupation may be within the guidelines. How that plays before the court is a separate consideration, but for me, a judicial determination based on individual fact and circumstance on cases which have been carefully and sensibly considered may not, shall we say, offend the spirit or letter of the guidelines. Also, the distinction drawn between business purposes, unregulated lending on residential property, which was actually referred to in the response, but not mentioned in the guidance itself, is quite intriguing and could suggest that action in relation to such lending is not intended to be barred. Again, I'm not an insolvency law practitioner or insolvency practitioner, so I think my first protocol would be to speak to someone like Simon or Alessandro and then basically let them tell me what to do. But I mean, if you think about it, are there any circumstances where repossession is likely to be in the customer's best interest? Possibly financially. But again, then it leads me into my final point of reputation management. So obviously any repossessions during this time will bring some reputational risk. So are there reputational concerns for lenders when enforcing breaches? I think yes, of course. However, as I've said earlier, it's all about treating customers fairly. Adhering to the guidelines of regulation is just one consideration for lenders. And even where action is considered permissible and commercially necessary recovery in an environment where the government and the regulators have set a clear tone does pose a potential reputational risk and will require carefully crafted recovery strategy and implementation. On that note, we will be back to Simon and Alessandro to implement that carefully crafted recovery strategy and implementation. But all in all, I think for us as a lender, it's interesting to hear both Simon and Alessandro talk about the issues they're having their side. But ultimately, we will be guided by what advice they give. So I'm really passing it back to everyone now. So that was just a little informal view of what us as a lender have probably felt over the last 3 months. But if you've got any questions, more than happy to listen to them. I think the floor's over to both Alessandro and Simon as well on that.
Hi everyone, so I will just have a quick look what we've got in the post bag. Any changes to protect business from default payment to complete work beyond usual small claims?
Sorry, can you just repeat that question for me, Sean?
Yeah, so are there any changes to protect businesses from default payments of completed work beyond the usual small claims?
So I think that would fall within the restrictions that are outlined in relation to statutory demands and winding up petitions. So a winding up petition can't be presented if it's less than £750, which is a relatively small amount. I suspect that figure will change eventually. But in that sense, there are protections for debtors where they have these debts that go over that level. They've got the protection of not having enforcement against them, at least within this relatively short period of time. It could be a longer period of time, of course, if the long stop date for the prohibition on statutory demands and wind up petitions is extended to October. So that's I suspect that the most relevant protection under that question.
Okay, got one here. A question for Alessandro. The moratorium seems to be very similar to a CVA. Are CVAs still available, and which CVA or moratorium will be more advantageous for the company and its creditors?
I think the reality here is going to be, it depends on the circumstance of the company. If the company is a large corporation, like I was saying at the end, many different tranches of debt, bondholders, trade suppliers, security, different levels of shareholder, I think the reconstruction and arrangement is going to be a good tool for them because it allows them to deal with different classes of creditors, not have to pay attention to different classes if it's going to not involve them at all. I think the CVA is still going to be more prevalent, more in number, because smaller companies will just have a better ability to use them. It'll be more cost efficient without the court applications with them, and the moratorium will be able to be used in tandem with the CVA to give it the protection to seek the proposal of the CVA and get its approval. And
another question on that: does the moratorium also restrict funders removing or seeking repayment of on-demand facilities?
Yeah, I just clocked this one. I think the reality of it's going to be in terms of removing the restriction, removing the actual facility. I don't think there's going to be a problem with removing the facility, because I can't remember reading anything in the bill that sort of specifically talked about it. But I can't imagine, just from a purely logic point of view, that you would not be allowed to stop lending money as a result of a moratorium. You know, get yourself further into debt. I would imagine you'd be classed as a, you know, it would be a sort of a moratorium debt, i.e., it's one that'd be classed in Group A because it's been incurred in the actual moratorium itself. In terms of seeking repayment of the facility, I think you will be, depending on whether you fall in that last bracket I was talking about during the presentation. Unless you fall in that last one in terms of financial contract, I think you're going to struggle to be able to take any action during the moratorium.
Thank you. Final question. Could you expand on the powers of the monitor?
Powers of the monitor, limited would be my answer. I think the only one that I can say they definitely have is to demand information from the company about its ability to meet its ongoing trading in the moratorium, but also about how the reconstruction saviour is going. The reality is it's supposed to be a debtor in possession process, so the company and directors remain in charge of its own fate. However, they have to make sure the monitor is happy that they are meeting that requirement to save the company's going concern and pay their debt. So as long as they can fulfill that to the monitor, he doesn't have any power to sort of get involved anywhere else that I can see.
Excellent. Well, that's all of the questions. Simon, I don't know if you've got any final thoughts. Do you want to wrap things up? Or?
No, but I'd just like to say thanks to everyone for dialing in on the webinar. I hope you found it useful from 3 different perspectives within this particular market. And I won't say anything beyond that, so you can get outside and enjoy the sunshine if you're not already there.
Well, thanks to Simon, Alessandro and Jonathan, and thanks to all of you for attending. It is really appreciated, just to echo what Simon just said there. So yeah, get yourselves out, get the barbecue lit, do the needful, and we'll speak to you next time. So thanks a lot, guys. Bye.